Y'all, Judge Whitaker is tired of the games. She's tired. And for the first time in the Young Thug trial, there was a motion for a mistrial, and the judge indicated that the motion was almost granted. And for the first time, we don't think it's the prosecution's fault. Let's talk about it. Hi, my name is Rochelle and I'm an attorney. Even though I'm an attorney, I'm not your attorney. And this video is for entertainment purposes only. It is not legal advice. Today we are talking about the Young Thug trial, and today the testimony of Detective Dennis and his testimony almost costing the prosecution their case and the judge to grant Mr. Weinstein's motion for a mistrial.
This one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice. They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Hear whatever response the state might be able to.
So, in case you're tuned in today, Detective Dennis was on the stand and he was testifying about Yak Gotti, and he was reviewing the photograph of Yak Gotti standing on the hood of the car of Rayshawn Bennett, aka YFN Lucci. Now, yesterday, Lucci's mom was on the stand and she identified that car as Lucci's car. So today, Detective Dennis was on the stand, and he was supposed to talk about the connection of Yak Gotti standing on YFN Lucci's car. Now, while giving his testimony, he alludes to the fact that just before this photograph was taken, Yak Gotti had recently got out of jail. Now, if you don't know, or you're not familiar with criminal proceedings, then testimony regarding a person being in jail that is a defendant in the case is a huge no-no. If you recall, Muntunk, when he was giving his testimony, he had mentioned not being able to talk to Shannon Stillwell because Shannon had been locked up. And if you recall, Mr. Shard, he objected profusely and he called for a mistrial because, Montauk had, mentioned that Shannon was in jail. And there was a question about whether or not the prosecution solicited this testimony from the witness because of their line of questioning. And ultimately, the judge ruled that, it wasn't grounds for a mistrial and moved forward because, they felt like a curative instruction could cure the issue of, Montauk alluding to Shannon Stillwell being incarcerated, and also the fact that Shannon was at the time being in the indictment. Shannon is also accused of being a felon in possession of a weapon, which obviously, in order to prove that charge, there will have to be evidence submitted to the jury about Stillwell's prior crimes. So this situation is pretty analogous to what happened with Montauk and Shannon Stillwell. The difference is that in that case, Montauk, he's been convicted of crimes himself in the past. He's not law enforcement and presumably has not had to offer testimony routinely. So, the court could potentially view that testimony very differently than Detective Dennis, who is law enforcement, who has presumably provided testimony in hundreds of cases before and would understand that, testimony regarding someone, being incarcerated or being released is just not, cannot be testimony that's elicited, right? Let's listen to Weinstein's request for a mistrial in this case, and also Mrs. Hilton's response to the request for a mistrial and the judge's ruling.
Don't get any last words. All right, I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness is a law enforcement officer, should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that this jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction, and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. What I am proposing to say as an instruction.
So as you can see, the judge reasoned that this situation is pretty analogous to what happened before with Montung, alluding to Shannon Stillwell being incarcerated and him not being able to talk to him as a result of that, to this situation with Dennis alluding to Yak Gotti being incarcerated shortly before this, being released from prison shortly before this photograph was taken. But to add commentary, in this case, Judge Whitaker indicates that if Yak Gotti was not also charged with being a felon in possession of a weapon, then she would have granted the mistrial because, I mean, a curative instruction potentially would not unring the bell given the stature of the witness. And so, when we listen to Weinstein argue his point, which is, Detective Weinstein's point is that Detective Dennis is a law enforcement, right? I think he's former law enforcement, but he has a law enforcement background. He is very well aware of what type of testimony can be elicited during a trial and what type of testimony is impermissible. And so him making this mistake and making these statements in front of the jury is highly prejudicial, and in his view, can poison the jury against his client. And given Detective Dennis' stature as law enforcement, the way the jury will perceive his testimony is very different than potentially someone like Montunk, right? Montunk is someone who was also alleged to be a member of the street gang. He has, he pled guilty. In this case, he has pled guilty in other cases. So the way the jury might view his testimony is very different than the way the jury would view the testimony of the law enforcement officer, right? So that's why Weinstein is making this argument that, hey, Dennis making this testimony is really, really bad. And there's no instruction that you can give to unring that bell and to make the juries disregard his statements, right? Because of his position as a law enforcement officer and what knowledge that brings and what power it brings. So ultimately the judge ruled, hey, that's true, but ultimately the jury is going to hear this information anyway as a part of the prosecution's case because Yak Gotti's being charged as a felon in possession of a weapon. So they were going to hear it anyway, but as a penalty, Dennis, you're out. You can't testify no more, okay? We don't want to hear nothing else. And so that's how we know Judge Whitaker is tired, okay? She has things to do for Christmas. She has plans with her family. She wants to go on vacation. She does not want to continue to hear the prosecution's case about Young Thug and his alleged fellow YSL members. And so she's like, listen, guys, we got heard this along. We got to go. So it's a really, really interesting kind of the judge's take on it. I know I've seen, lots of comments on TikTok, etc., about people really feeling like, why won't the prosecution grant this? Why won't the judge grant this mistrial in this case? And so if you guys want me to talk about kind of the legal standard behind why or why not a judge would grant a mistrial, we can talk about it in a future video. Now, I will give you just a little precursor. In this particular case, there was a request by Brian Steele to have a speedy trial, right? And with the request for a speedy trial, it means that the trial has to occur within a certain time frame, right? Based upon when the indictment is filed, when the motion for speedy trial is granted. My understanding, and I have to do more research on it, is that if there is a mistrial that is granted in this case, the time that the prosecution would have to bring the case again, right? There's not sufficient time. So if there was a mistrial granted, there would be no opportunity for a retrial. And so I think that is kind of the undercurrent of why the judge, I believe, is electing to continue forward with the case as is, and ultimately, deciding to try to have curative instructions or take some other measures to educate the jury, or try to remedy evidence that's offered that shouldn't be offered, or statements made by the prosecutors or the defense that really are improper. She's trying to, toe that line so that there isn't this issue with, hey, if I grant this mistrial, the case cannot be brought again because of this issue with the timing and the speedy trial motion. Now, we can get further into the law behind it if you guys are interested. If you are, please comment down below. Thanks for watching. Please like, comment, subscribe, and I'll see you in the next video.